Hello students, here is Ashu Gupta, Assistant Professor. Again welcomes you all on the behalf of the Indraprasth Law College. In today's lecture, we are going to discuss about the intervention, and in today's lecture we will discuss about the meaning and the kinds of intervention. Then first of all, we have to know about that intervention. What is intervention? In the terms of the international law, the intervention prohibited by international law is actually defined as dictatorial interference by a state in the affairs of another state. There are few interventions which can be justified by right and as such not a violation by the intervening state of the independence of another. Intervention is dictatorial interference by a state in the affairs of another state for the purpose of maintaining or altering the actual condition of things. Mere friendly advice and general political influence do not strictly come under this term, as essential requisite of intervention are the use of force or a threat to use force is lacking in them. The interference must take an imperative form. It should be forcible or backed by the threat of force. A dictatorial interference is an interference by the threat or use of force. It is evident that general international law does not prohibit intervention under all circumstances. Forcible interference in the sphere of interest of another state is permitted as a reaction against a violation of international law. There are three different kinds of intervention, which are internal, external, and punitive. According to the provision given in the United Nations Charter, Article 2 of the UN Charter implicitly prohibits intervention on the part of individual state when it ordains the member to refrain in the international relations from the threat or use of force against the territorial integrity or political independence of any state. International law, however, permits intervention as dictatorial interference by one state in the affairs of another state, only as reaction of former against violation of its rights by the latter. Such a doctrine is possible only if the bellum justum principle is recognized. This is a Latin term, bellum justum. Now we are going to discuss about the kinds of intervention. As we have mentioned already that there are three different kinds of intervention, which are internal, external, and punitive. If we talk about the first one as an internal intervention, it is the interference by one state between the disputing sections of community in another state, either for protection of legitimate government or the insurgent. In the year 1936, number of states intervened in the civil war of Spain. Now, if we talk about the external intervention, then in the terms of international law, it is the intervention by one state in the relations, generally of the hostile relations of other states. In other words, it is an intervention in the foreign affairs of another state. Such intervention being directly against hostile relations of such state. This kind of intervention is tantamount to the declaration of war. The entry of Italy in the Second World War, siding with Germany against Great Britain, provided an example of external intervention. The last one is punitive intervention. It is a punitive measure falling short of war and is in the nature of reprisal for an injury suffered at the hands of another state. It is frequently carried out by stronger nations towards weaker nations, a pacific bloc to compel the observance of treaty engagements or to redress some breach of the law affords an illustration of this type of intervention. So these are the three modes given in the international law as the kinds of intervention, that is internal, external and punitive. Now we will discuss about the grounds for intervention. There are some grounds for intervention given in this chapter. The first one is self-preservation. The second one is enforcement of treaty rights. Third one is grounds of humanity. Then balance of power, protection of persons and property, intervention in civil wars, collective intervention, and some other grounds which are described as the grounds of intervention given in the terms of international law. If we talk about the self-preservation, the supreme interest of the state overrides the law. The right of self-preservation is more sacred than the duty of respecting the independence of the other state. A state has right to interfere in the affairs of another state where the security and immediate interest of the former are compromised. Interventions in order to ward off imminent danger to the intervening state are justified by the force of circumstances. The danger must be direct and immediate, not contingent and remote. Then, enforcement of treaty rights. A state is justified in interfering in the affairs of another state if the provision of any treaty obliges the former to preserve the independence of neutrality of the latter. Such intervention does not violate any right of independence because the state that suffers has conceded such liberty of interference by the treaty. On the terms of grounds of humanity, another justification is based on that, and Lawrence observes that in the opinion of many writers such intervention are legal, but they cannot be brought within the ordinary rules of international law, which does not impose on states the obligation of preventing barbarity on the part of the neighbors. The next one is balance of power, wherein the doctrine of necessity of a balance of power observes Fenwick between the leading states as the basis of mutual self-protection dominated the international relations of the 19th century. Most of the interventions in the Balkan Peninsula should be regarded as interventions in consonance with the policy of balance of power. Intervention on the ground of prevention of the balance of prevention has been condemned by the jurists of all ages. The next one is protection of persons and property. Protection of the persons, property, and interest of its nationals may provide justification for intervention. The necessity for protection may arise due to gross injustice or due to injury caused by unfair discrimination. If we talk about the collective intervention, the point of collective intervention at the present time is in pursuance of the provisions of the Charter of United Nations. Under the authority of the UN Security Council in accordance with the Chapter 7th of the Charter, intervention in civil wars with the establishment of UNO, there is no justification for intervention by the individual states in the civil wars of other states. The UN Charter imposes an obligation upon states to refrain in the international relations from the threat or use of force against the territorial integrity or political independence of any state. So these are the some grounds which are given in the chapter of the intervention. Hope you will enumerate it into your study. We will meet soon again. Thank you.